Well, good morning. I just introduced myself. I'm just going to give a quick overview of First Amendment doctrine as it relates to challenges to anti-panhandling laws, and my fellow panelists will talk about specific cases and some of the issues that they've seen come up. One of the reasons why we talk about First Amendment in these sorts of cases is that it's really hard to find a good hook to challenge laws that criminalize homelessness, a good federal constitutional hook. We've had some luck in some cases, but for the most part, the First Amendment is really powerful because the Supreme Court has interpreted it broadly to protect all kinds of terrible things. And so we are using some of that precedent and saying, hey, that applies to unhoused people too. If you can fit a case into a First Amendment framework, you're on much better footing. You have much stronger legal arguments, as the food sharing is actually a really good example of the case that Kirsten mentioned and litigated. So one of the first questions when you're thinking about First Amendment litigation is the thing that you are seeking to protect, is there speech involved? And so the food sharing is a really good example of some of the creative, I guess, extensions or applications of that rule. In the panhandling context specifically, the Supreme Court has repeatedly said that soliciting donations is protected speech, at least when it's in connection with a charitable organization, a religious cause, a political donation. Ellen might talk about some of the challenges that could be brought to that, but right now I'm going to assume that panhandling is indeed protected speech. It's an expression of need, so that seems like core classic speech elements. When challenging a law, the question then becomes, is this law content-based or content-neutral? And that changes the level of scrutiny that the courts will give it. A content-based law is subject to a higher level of scrutiny, more likely to be struck down as unconstitutional than a content-neutral law. So a content-based law would be one that says no standing on the median discussing sports. That would be one that draws a distinction based on what you are saying. A content-neutral law is one that says no standing on the median, period. That doesn't draw a distinction based on what you're speaking. Before 2015, there was some confusion. The Supreme Court had said arguably inconsistent things about how to make the distinction between whether a law is content-based or content-neutral. As advocates challenging a law, you want it to be considered content-based because that gives you an easier path to victory. In 2015, the Supreme Court clarified the law. If you're lawyers, a lot of this is probably familiar. I apologize. I'm just giving a quick overview, I hope. In 2015, the Supreme Court decided Mead, which is a case that we reference all the time in the anti-panhandling litigation, because it made it a simple test. It said you primarily look to the text of the law and see if the text of the law draws a distinction based on the content of speech. Before, there were some other mushy tests. That test is helpful because it's rigid. Many people don't like it because they say it's too rigid. But if you're representing unhoused people, you want to do everything to prevent the judge's biases and stereotypes and prejudices from coming in. So a rigid test is actually very helpful in that regard. So since Reed was decided in 2015, lawyers have used it to challenge anti-panhandling laws. Any law that references panhandling, that says you can't panhandle across the city, or you can't panhandle near a bus stop, or you can't panhandle near a roadway. Anytime that a law mentions panhandling under Reed, under the Supreme Court case of Reed, that is content-based, presumptively unconstitutional. So lawyers have had a great string of success striking down these laws. In fact, all of them, or basically all of the laws challenged that mention panhandling, have been struck down since 2015. So that's good news, right? So some maybe not so great developments came this year when the Supreme Court decided a case called Austin versus Reagan advertising. The case wasn't about panhandling at all. It was about advertising billboard signs and whether a sign is on premises or off premises changed the size of the billboard that you could have. Unfortunately, I think the court kind of scaled back Reed a little bit. the court said that Read's rigidity is a little too rigid. And instead, the new task for deciding whether something is content-based or content neutral is whether the government is essentially attacking the core communicative message, which is a little mushier. And if my fellow panelists have a different take, please, of course, let me know. One of the most troubling aspects, though, in Austin was that the court went on this lengthy discussion of solicitation laws, not relevant to the case at all. But the majority said solicitation laws are a classic example of a content neutral law. Well, that kind of screws up a lot of arguably screws up some of the arguments that we had advocates have been making. The court didn't quite say anytime you target solicitation, it's content neutral. Instead, the court said if you target solicitation of all sorts, so you target solicitation for commercial and charitable causes, then it's content neutral. I'm sorry, then it's content neutral. If you just target a particular type of solicitation implicitly, that would still be content-based. And so because most anti-panhandling laws say you can't solicit donations, you can't solicit charity, we should continue to argue, and hopefully we'll be successful, that those laws are content-based. So already lawyers are starting to deal with it. The law firm that is hosting us has filed briefs arguing that Austin should be read aggressively to consider anti-panhandling laws as content neutral, and therefore more likely to strike down. But Kirsten and Ellen and others on their team have filed a great brief, which I recommend if you're litigating this issue. Also, Eric Foley at the MacArthur Justice Center has filed a brief on this issue. And I have some further thoughts if anyone is litigating this on like a handout that I can give you on like ways of distinguishing Austin. So one further thing, two further things to note. Justice Breyer wrote a concurring opinion in Austin. And in this concurring opinion, he goes out of his way to say anti-panhandling laws, among a whole list of other laws, are the sort of reasonable regulations that should be upheld. And he laments that under the current doctrine, that's not that's unlikely to happen. Well, so that's not great, right? We don't like having justices single out the laws that we're challenging as things that should be upheld. The good news is it was a concurrence for himself only. He then immediately retired. And it's a lament, right? He's sad that these reasonable laws are being upheld. Are being struck down, where of course we are happy that these reasonable so-called laws are being struck down. So in fact, you can use Breyer's concurrence as further support for your position that it doesn't change the analysis. The final thing I'll say is that even if a law is even if an anti-panhandling law is considered content neutral, whether because of an expansion of Austin or just because a city passes a law that says something like no standing on the median as a way of attempting to restrict panhandling near roadways, courts have also struck those laws down under their content neutral, but the government still has a pretty significant burden to show that the laws are narrowly tailored. A recent example is a federal appellate court, the 10th Circuit, affirmed the invalidation of Albuquerque's law, which prohibited things like standing on a median narrower than 6 feet. Even that, the court said, it was a content neutral law, but the government did not sustain its burden of showing that it was constitutional. So there are still lots of arguments to be made, but that's the general framework for litigating these. So with that, I'll turn it over to Kirsten.
Just one thing that I'll note, the Law Center has a litigation summary supplement that's available on our website, homelesslaw.org, and it provides analysis, the success of panhandling cases post-Read, and you'll also get short summaries of each of the cases. It's a good handy reference guide for starting your research. Thank you very much, Joe. Welcome, Kirsten.
Hi, everyone. So I'm going to talk to you a little bit about a case that actually Tristia and I did together. When I was at my prior organization, Southern Legal Counsel, which is a statewide nonprofit public interest law firm in Florida. And we also did this case with wonderful pro bono partners with the Law Center, a team, Julia Schmidt with Patton. What's the full name of that firm?
Patton, Meacham, and
Yeah.
Rosenman.
Rosenman, that's right. And it was really a great experience that we had together. So just to give you a little bit of a background about it, the name of the case is Vigue versus Shore. Our client's name is Peter Vigue, and he was an unusually hardy speaker, is the kind of the term in First Amendment jurisprudence. He liked to fly a sign, as they call it, have a message on a cardboard sign, and would stand on the shoulder of public roadways or in the median. One of his favorite spots was like a median that kind of came in and out of a public shopping center. And he, no matter how many times he got arrested, cited, or had told to stop, he would be out there the next day. And actually representing him made me understand in a really powerful way how much this really is communication. Because one of the reasons why being arrested would not stop him was that it was really a way for him to meet people and get to know people and talk to people about his life and his needs. For folks that usually experience a tremendous amount of social isolation and kind of marginalization, that's actually how he met his lawyer who represented him pro bono, and was, him and his brother had met Peter because he was flying a sign, and they took him to coffee and talked to him about his life. He was a local lawyer in St. Johns County, Florida, and in St. Augustine, Florida, who had never done a First Amendment panhandling cases before. And the local legal aid there had put him in contact with me. And so he started filing motions to dismiss because I said, hey, the statute that he's getting arrested under is facially unconstitutional. It's already been declared unconstitutional by multiple federal courts in Florida, but it's still on the books. And tons of, if you don't have a specific injunction, there were a couple sheriffs in cities that had injunctions against them. People were still enforcing it, which I think is a problem with like the limits to our remedies, right? You get an injunction, you got it against a city or a county or a sheriff. Well, okay, there were 2 sheriffs in Florida that had injunctions against them, but there's 6 or 7 sheriffs in Florida. So, that's an injunction feels really powerful, but then you were kind of seeing the limits as long as it was staying on the books with the Florida legislature. And so he kept filing motions to dismiss, and the court kept dismissing them. The prosecutor would null pros them. They would not file, the charging, the information to charge the crime. But the police continued to arrest, continued to warrant. And so he said, hey, need some help. We got together and we filed a complaint, we filed an injunction. We got a preliminary injunction, and we ended up suing both the Florida Highway Patrol and the sheriff. And Florida Highway Patrol ended up being a really interesting situation because they are our state police. They, enforce statewide, and these statutes are in the traffic code, which is really what they're responsible. They're responsible for rulemaking around the traffic code. They're responsible for doing what's known as the uniform traffic citations. And so it's like a database that police can just go to and pull the citation, fill it out, and give it out. And so I give all that background to say that we ended up reaching a really interesting settlement that ended up being one of the most impactful settlements I've ever had in one of these cases. that actually gave me creative ideas for other cases too, and I just wanted to share. First they agreed not to enforce it. And one of the things they did was they agreed to remove the statutes that were unconstitutional from their uniform traffic citation database, so that it was just not available to any law enforcement agent in the state. And if they wanted to write a ticket for it, they had to be like, know about it, write their own ticket. It was just not available in the database. They updated their manual to say, this is, not a statute we should be using. They did a legal bulletin that they circulated to the Florida Police Chiefs Association, the Florida Sheriff's Association, the State Law Enforcement Chiefs Association, telling them, we are no longer enforcing this. Basically, you shouldn't either. They also agreed, because every year as a state agency, they do a legislative package to the Florida legislature. They agreed to propose repealing, and then for one, we had agreed on some language to rewrite it. So it was an actual like impeding traffic statute, and not just like standing on the side of the road looking like you might be impeding traffic. And it worked. They proposed it. The legislature that session repealed it, removed it, and that was like nearly 20 years after the first injunction that had been entered in that statute. So that was just all from this settlement that we had. The other thing that Tristia asked me to talk about a little bit is that we got a permanent injunction, and we also had a claim for damages. And not a lot of us focus like on injunctions, but I just want to talk a little about damages. I think these cases are worth damages. First Amendment cases, are worth money. And I think we shouldn't be leaving that money on the table, because the folks that are getting these laws enforced against them are poor people. And it's kind of outrageous that in America, you can get arrested for the words you have written on the sign, for the fact that you were communicating a message of need. And I think we have to hit back in every way that we have. And so in this case, we ended up getting a significant damages award, but a settlement. But the court made us brief, and it's in the materials, whether or not in a First Amendment case you were entitled to more than just nominal damages, which was like, $1, just kind of for the significance of the value of the First Amendment, or if you were entitled to what's known as compensatory damages. So we did a brief, and we proffered what we were going to prove at trial, saying that you are entitled to more than just nominal damages if you prove an actual injury above the deprivation of the constitutional rights. So something plus the First Amendment violation. And so that something can be things like loss of liberty. So like going to jail. It can be emotional distress. It can be actual out-of-pocket losses, economic losses, in terms of having to pay for court costs or things of that nature. Since he had such an amazing pro bono lawyer, he had every criminal defense proceeding terminated in his favor. Like, he had no convictions. And so we had like 11 arrests with no convictions. And then we also had a very aggressive sheriff's agency that continued to enforce repeatedly after we had an injunction. They were out there, they retasked a police officer who was on their vice unit, who usually investigates like sex crimes against children, was out there surveilling our client, and taking photos, taking videos after we had an injunction. After we had an injunction, it was really outrageous. One other thing I would say in terms of like how we were quantifying is that it's really important, especially in a First Amendment case, to look beyond the arrest, beyond the citation. So we made sure we had copies of every written warning, every verbal warning, and we got all of the CAD notes, which were all the dispatch records. And so they have codes for like every time they've had a contact and told him to leave the area. And so we took a deposition just of like somebody who could interpret that record and went through. And by the time we were done, I mean, we had dozens and dozens of stops. And so every single one of those is a violation of the First Amendment because you're interrupting your ability to speak. So that was BB versus Short. Anything else?
One follow-up question. At one point, they tried to get his medical history, and I'm wondering if you could talk about that.
Yeah. Well, first of all, they called it an emergency motion. And the first line of our response was, "This is not an emergency." You know, and we quoted a case that said, you know, an emergency is like, you know, when someone's about to die, or like a ruinous calamity is going to befall the community as a whole. Like, this is not that. And so basically what they were saying is that they needed to get discovery into his mental health history because they didn't realize he was so disabled, or, you know, something like that. And procedurally, the main reason why I think we were really defeated is that it was so late, like they had waited so late and they were trying to modify the scheduling order. So we were able to kind of beat that back on procedural terms, but they were also trying to ask for very intrusive medical records that, you know, I think they probably wouldn't have been entitled to anyway. So we had a lot of kind of disputes about what they were asking for. Like, they wanted to get into, like, you know, the determination by Social Security for his disability application. You're just not going to be entitled to that. However, when you ask for emotional stress, it's beyond garden variety emotional stress. So garden variety emotional stress is just the ordinary distress that anyone would feel in that situation. It can generally be inferred from the circumstances. But if you're asking for something more than that, like, I can't sleep at night, I've, you know, developed this diagnosis, that those kinds of emotional stress damages, then you could be putting your mental health at issue, and they could be entitled to medical records and things like that. So that is something to consider in terms of the types of damages you might want to claim, and whether or not it's worth it, particularly for people who, you know, might have pretty significant mental health histories.
Thank you, Kirsten. Okay, we are going to bring up Ellen, and everyone, thank you for being tolerant of the
No password.
Yes.
I have my computer with that one.
That would, you know, what the issue is, well, maybe we do screen share here. I think that will mean people in the, yes, I'm going to email them to you. And for their virtual audience, what we're doing is making sure that everybody can see Ellen Degnan's slides. And of course, here we go. It's taking a little bit of time. Stand up, stretch. I'm going to take a look at the CLE word as well. Good time to grab coffee or water. What is that? This is the computer that will project, and this is the AP Gump computer, but yeah, but there's no password. So if we would be able to find somebody, that's great. Alex also said that she's able to project it. I did email you. Got it. Okay. Looks like Joe is handling that. So while he does that, I am going to pull up the CLE words. And don't forget, y'all, you have to sign in. We've got the sign-in sheets here. Does everybody who wants CLE credit, have you been able to sign in? Okay, so let me get you the first word. So for today's session, they have, thank you very much. The first CLE word is share. Share. I apologize for this. Maybe what we can do is while we're waiting, we can go a little bit out of turn with what we were talking about. Jennifer, we're going to switch this up. So, we're going to go back to Ellen, and she will also talk about panhandling and some really unfortunate developments, as well as great ones happening in Alabama. But let's transition now to a discussion of expressive conduct in the form of protests, especially around protest camps. We've got Jennifer Sastrom here to talk about some work that she's doing in that area. Jennifer.
Thank you so much. I want to start off by just giving a quick intro on the importance of expressive conduct and kind of the way in which we are making these arguments. Clark versus the Community for Creative Nonviolence is a case that went all the way up to the Supreme Court related to National Park Service regulation related to encampments in Lafayette Park. Although there was an original success in the district court, a loss in the district court, success on appeal, the Supreme Court ultimately reversed the decision anyways, finding that although there was expressive conduct, it was a reasonable time, place, and manner restriction. So just to kind of frame how I want to talk about issues is thinking about kind of how to and thinking about litigation and reinforcing the expressive nature of the conduct and then the lack of reasonableness regarding the regulation. And there are kind of a variety of things in the way that you can articulate what the problem was. So thinking about, and what I'll talk about briefly is that there's a way to make a First Amendment retaliation claim where that you are being punished in some way for the nature of your speech, and that might be a little different than the way you articulate a First Amendment associational claim where your right to engage with other people is being abridged. So just highlighting that there's also some flavor and nuance in the types of way that First Amendment claims can be developed in this field. That and in terms of, I'll just kind of, for the sake of time, skip to really talking about the McGill case, but can give some other kind of examples and articulation kind of the standard in terms of restrictions that are justified and whether they leave open sufficient ample opportunity for alternative communication in some of those cases. But turning to the McGill case and to give the context, this was the harms in this case arose during the summer of 2020. A large group of individuals in the wake of George Floyd's murder came to the area that became known as Abolition Park, also known as City Hall Park in New York. This is extremely proximate to both the police department, the mayor's office, and other key office holders and individuals in power. So they set up there originally for kind of repeated protests, and it ended up becoming kind of an encampment style, Occupy style protest. The community was there for over a month, really developed a network of services and engagement, had partnerships with local businesses that allowed them access to really maintain this community. Despite being there for that time, for that amount of time, really without issue, the police at 3 a.m. Came in and essentially cleared the park one July evening. Because it was done at such a late time of night, there were very few people and individuals there. So those who were present, some of them were able to grab some of their belongings and flee, but for the most part, much property was kind of left behind because of the way that they did this particular clearing, and a lot of property was lost. There were a couple of arrests as a result of the clearing, but the clients who we were engaging with we're primarily thinking about the harm of both losing kind of their right to engage in that space, but also the loss of all of their collective property. And while our two named plaintiffs in the case are not unhoused individuals, right now they've experienced housing insecurity in the past, and we realize that this is a case that has impact more broadly in terms of setting a standard that could apply to other individuals. So the current status of the case is that it's currently kind of in discovery, and so I'll speak in a less direct way about our clients, but some of the questions that this type of litigation can raise and that should be thought about in these types of challenges. So the first is causation, and thinking about actually making the link between the speech and the nature of what's being discussed and whatever that adverse action is. So, failure to train might be, one possible iteration of that. But that, as one example of kind of indirect evidence that can help support that inference. Because oftentimes there's not going to be an email that directly says, the incriminating thing you wish it did, even though it might have been, said or thought by others in the room. So trying to think about ways to use circumstantial evidence to link causation. And some of that can be through, publicly available, reports, other types of public statements by elected officials, legislative history of particular statutes, and thinking about how to best draw those inferences. The second is whether, in terms of thinking about harm, I'll skip over kind of some of the complexities that Kirsten already addressed so well in terms of proving up certain types of damages, whether, in asserting something like mental health, damages, does someone even have access to that type of service and care? But even if they did, what is kind of the documentation, the history, and kind of the causation to the harm? But separate from that, there are other kind of complexities or other complexities that are more easily overcome. So one is the idea that there needs to be actual chilling in the First Amendment context. That is one way to show that I was engaging and then I stopped engaging because of this thing. That is one type of way of articulating the harm, but that is not required in First Amendment cases. So to quote from an NRA versus Cuomo case out of the Northern District of New York, that actual short speech is not necessary to make out a First Amendment claim, and that they can show that, plaintiff can show that if, quote, either his speech has been adversely affected by the government retaliation or that he has suffered some other concrete harm, i.e. the loss of property, physical belongings would be part of that actualized harm in being able to, as an alternative to this actual showing. So someone can continue to protest, continue to engage in this type of activity, and that doesn't undermine their ability to say that they were. Also making or just flagging a caution though that probable cause can defeat retaliation that has been found in many cases. So that can kind of limit the accessibility of this claim in certain contexts. But, as in the example of our McGill case, neither of our plaintiffs were arrested in that case. And so there's not any kind of citation or arrest warrant that would preclude this type of claim. And then just a couple of other quick things is the idea of actual knowledge. And again, being able to show that, that a First Amendment retaliation claim does not exist where defendants have no knowledge of the protected speech. And again, that it may require a little bit more to that and going back to the first point on causation, but really being able to show the link of that there was knowledge that this type of activity was going on. And that might be easier, for instance, to show, on a interaction directly with like a law enforcement officer, and maybe harder to do if it is the mayor, a city council, or a body of people that are kind of more diffuse and removed from the direct harms of the situation. There are also challenges and limitations related to class actions in this space, either because of numerosity. In one case in California, 25 people was not found to be enough for a class action, or kind of the similarity between situations and knowing that, even if the same thing happens, it might have been in different places, different circumstances, and that kind of requires individual litigation as opposed to class actions. And then last slide is administrative exhaustion, depending on your jurisdiction and what might have happened in that particular case. There may be other steps required. So in our McGill case, we contacted the state's comptroller office and made sure that we filed a notice of claims in order to try to ascertain and confirm that they did not have their property in anything that was confiscated. And so being able to check off administrative exhaustion requirements in litigation. I will say that those are some of the legal considerations in addition to a broader kind of community understanding on data, coalition building, multi-pronged advocacy approaches, and how this also fits in with other areas of related advocacy. So, for example, documentation in these types of instances is important, but only about half of our circuits have officially recognized the right to report police under the First Amendment. So, continuing to extend coextensive protections that then can also help with kind of the data and proof in even these types of cases. And just last notice to highlight both the role of organizations and the way that they can serve as plaintiffs in certain types of cases, including in retaliation claims where they maybe have clear history of advocacy on certain issues. And lastly, to highlight the role that First Amendment in data transparency and access to information about these types of policies and issues and how they are implemented, and why that's something that is also an important part of being able to move forward all of these other pieces. I'm happy to share other examples and discuss further, but I'll stop there in the interest of time. Thank you so much for this opportunity to share with you all.
Thank you, Jennifer. I have a follow-up question for you. So, in the context of homelessness, encampments often arise as a matter of survival and community. But there's also, an expressive element that is inherent in that community. And I'm often asked, and I don't have great answers to, how can we structure the survival activity that we're doing in camp, which is, the primary motivation? How can we structure it such that we're able to raise First Amendment arguments when we are threatened with destruction of our camp community? Any thoughts about that?
I think being able to highlight the expressive nature of the activity, and I'm trying to find, there is a case that I came across that talks about how it has somewhat unfavorable language in this respect, where just having a tent and existing in a public space and being visible in a public space is itself not enough to indicate expressive activity. And so, although there are other cases that have found that type of community and coming together is itself expressive, and there are cases, including one out of Denver, that acknowledge this being an active response to the homelessness crisis, in Ohio and Cincinnati, where this was directly responsive to highlighting the city's homelessness crisis. But just being there may not be enough. So I think trying to highlight the message that is being communicated, being able to point to things like signage or the verbal interactions that people are having with folks to really elucidate the requests that are being made and the nature of the conduct as being what you described, but also being fundamentally expressive in order to get that First Amendment vote. So I appreciate that question.
Thank you, Jennifer.
No,
Please, yeah,
I just
please.
didn't know if we were doing questions at the end, but please go ahead.
Help me understand some of the triage and issues by this in terms of facts of the outfit. Was there a statute here that is decided for statute? If you rule out the fact that the statute did have a space violation?
This was not a statutory case. So this was just folks who were there present, and the way that they were cleared. It wasn't as a result of any particular statute. It was that they were moved out of that space out of expressive conduct, but that then all of their belongings, instead of being properly vouchered and stored with the city as they should have been for essentially their kind of standard protocol, it was all discarded and trashed. And so that response was directly related to the speech and the anti-police messaging that the folks there were espousing. And it was the same entity that then threw away those belongings. And, again, there's still, possible causality and other, that required that kind of support. But this was, just able to be kind of a constitutional claim on, based on what occurred. There were other claims, including a Fourth Amendment and 14th Amendment claims that were coupled with the First Amendment. So I do want to acknowledge that it wasn't a First Amendment claim alone. But I think the retaliation piece is an important lens, and also not just legally, but also in terms of actually recognizing what happened and the narrative around the community that was there and that got dismantled.
Very helpful. Thank you. Okay, and now we are inviting up Ellen. Ellen, do you want to sit here? This is the computer that will allow the projector to.
I guess
advance.
or I could
I think. Oh, actually, yeah. This one is relatively untethered.
as long as it doesn't. Yes, yeah.
Cool.
Let's go back one.
Yes, and actually, this is the.
Oh, sweet.
And yes,
So I can just like.
no, so sorry. We've got the two. I think Alex has control over the one that is projected to the virtual audience, and that'll be reflected here.
Okay.
So you can largely ignore this.
Okay.
And this is the one that you'll be advancing for folks in there.
Awesome.
Cool. Thank you, Ellen.
Yeah, hello everyone, and hello folks online. My name is Degnan, and I am gonna share with you the first and only case that actually my organization SPLC and that I have brought involving the right to solicit donations. And I'm gonna start with kind of a background story around how we learned of these constitutional violations, give an overview of the procedural history of the case and where it is now, and then kind of home in on two stages of the case. So one being class certification and then another being summary judgment. So yeah, and feel free to interrupt whenever to ask questions. I don't mind being interrupted. Okay, so in around July of 2019, we caught wind, actually thanks to my colleague Micah over there, who sent an email, that the city of Montgomery was discussing an ordinance that would criminalize soliciting donations. I mean, often it's called panhandling. Certainly it was called panhandling in Montgomery. And really, Montgomery didn't need to pass this ordinance because they already had, city police had authority to enforce existing state statutes that criminalize soliciting donations. We weren't even aware of those. This just really wasn't on our radar until it became a local issue. Kind of moving quickly through the next 6 months, we got together with an incredible coalition of clergy people, service providers, organizers in Montgomery, and were able to derail that ordinance along with a second version of the ordinance, which somehow they thought it would be better to criminalize the people giving the money. I mean, obviously that's not going to fly. In any event, the ordinances were kaput, but the city police the city police were still very actively citing people under two statutes, which I will show in a moment. And so we sued the city, we sued the county, which also had authority to enforce these statutes, and we sued, the county sheriff, and we sued the state via the secretary of the Alabama Law Enforcement Agency. The sheriff and the secretary are both state actors, so we sued them under Ex parte Young in their official capacities. So finally, a slide. This just kind of gives you a snapshot of, what the case looked like when it started and where it is now with summary judgment pending. In sum, we filed on behalf of 3 named representatives of a, putative class action. And as I said, we filed against 3 defendants. Very sadly, 2 of our clients passed away. Mickey died this year and Ricky died at the end of last year. And so Yeah, and we also settled with the city and we settled with the county. And so now the only remaining defendant is the state. And yeah, the kind of substance, right, of the case, I've already mentioned. It's a First Amendment challenge to two state statutes that facially criminalize soliciting donations. And originally, as I mentioned, we were also challenging, well, I guess a different ordinance, the city ordinance that incorporated by reference those two state statutes and therefore authorized city enforcement. Once we settled the city, obviously, we were no longer challenging that ordinance. So we are seeking declaratory and injunctive relief. We're not seeking damages, though, maybe we can talk after this about pros and cons of doing that and how we might have done that. Yes, and as I mentioned, those are our plaintiffs originally and our defendants. So these are the statutes. We refer to them as the begging statute and the solicitation statute. I've highlighted, let me just actually read them. So the begging statute, which I will note is the very statute that Justice Breyer called out in his concurrence. I mean, it's like, wow, okay, Alabama, right? Like, called out in his concurrence as being reasonable, which we did not note in our motion for summary judgment because it was, but any event. So begging statute prohibits a person from loitering, remaining, or wandering about in a public place for purposes of begging. The solicitation statute prohibits a person from standing on a highway, which in Alabama is construed very broadly to include literally any street. Whether it's, a sleepy one-way street with a stop sign in a neighborhood or, highway, actual highway. So you're prohibited from standing on a highway for the purpose of soliciting employment, business, or contributions from a person in the car, unless otherwise authorized by official permits. And it would be the local entity that would be awarding that permit. We'll talk about permitting, I think, in a little bit, but spoiler alert: there were no other, there's no other guidance, no other restrictions in state law about, how these permits should be issued, right? Like, absolutely no guidance. Nor was there any permitting process in Montgomery or any other city or county that we are aware of. So there just were no permits; it didn't exist. And I guess I highlighted some of the, the differences in languages because, they could be quite important for the reasons that Joe mentioned earlier. You'll notice that the begging statute expressly, targets begging, right? Like it singles out begging. It's not restricting any other object of solicitation other than, expression of need. But the solicitation statute regulates both commercial and non-commercial solicitation, which is a lot trickier now that we have Austin. And we can get to that a little later. But I don't need to go through all of this. It's really also some of these slides are just so, if you want to have this handy for yourself afterwards, you can look at it. But long story short, we settled with the city, settled with the county. And but before settling with the county, we did win on our motion for preliminary injunction, which was great, and on our motion for class certification. And let's see, at this point, we are past briefing summary judgment and just waiting. So I want to talk a little bit about class certification. This was our proposed class, and this was the class that the district court approved or certified rather. So all individuals who will in the future stand on a public street in the state of Alabama for the purpose of soliciting employment, business, or contributions, or loiter, remain, or wander in a public place. So you'll notice that the two kind of subclauses simply excerpt more or less, right, the statutes themselves. And yeah, I wanted to pull a few excerpts from the order because actually, as someone newer to this area of law, I didn't realize just how useful this statement in bold is. So the court said, look, your plaintiffs are necessarily indigent, probably homeless, and in fact, they are homeless. The class mechanism provides stability, protection against mootness, and ensures that the action can continue should a named plaintiff go missing. That is value enough for class certification. I mean, it's a pretty broad endorsement of class certification, where plaintiffs live, like, frankly, very unstable lives. I will, I'm not going to read through all of this, but I did want to, it's also probably too small for people to see, but I did want to kind of share a little bit about the team's analysis of whether to bring this case or whether to pursue class certification. Our primary motivation was the concern that we would build a relationship with the importance of building relationship, right? like with your clients, and then also the fragility of those relationships in some cases. So, it's really painful to say, but I mean, two of our clients died, right? This is it. I don't know what else you have to say. You know what I mean? Yeah, sorry. And so yeah, we wanted the court to recognize that without access to stable housing, without access to stable communication, or transportation necessarily, it can be very hard to maintain a relationship with your client. We've done, I think, a really good job. We've certainly tried. And even so, we hear from our clients all the time, minutes have run out, we gotta stock them up on the phone again. And so I won't go into too many details about our clients, but that was the rationale. And just briefly, right, some other kind of useful quotes from the class certification order. I'll note that that the court was persuaded, right, on the issue of numerosity, in part based on figures showing enforcement in the recent past, even though we were showing enforcement by city police that were not involved in this litigation, right? Because the point is not to show, the point is just to show that people are engaged in this activity, right? And so if you can show that they're being criminalized, that's enough, regardless of really who's criminalizing them for it. Let's see. I'll also note that because our challenge was a facial challenge, it's particularly well suited for class status. It's just a lot easier. You can satisfy commonality and typicality quite simply. And also because the evidentiary burden at the class cert stage is higher than it is at pleading. And because when you're bringing a facial challenge, generally, certainly in our case, you don't need to, the kind of factual showing is far simpler. The facial challenge, right, was beneficial for that reason as well. And then finally, also, we were seeking injunctive relief and not damages. It would have been a lot more complicated had we been seeking class damages. I'm probably taking too long.
No, you're doing well.
Okay. Cool. Motion. So now I'm gonna skip to our motion for summary judgment. I want to hit briefly Austin, and I want to hit the state's pretty radical response to our motion. So our arguments were fairly, those that you would expect. One, the statute fails strict scrutiny. See Read. Two, even if they don't, they would fail intermediate scrutiny. And we reckon, and then the second argument is that the pedestrian solicitation statute specifically, which, if you'll remember, is the statute that was a little dicier under Austin because it criminalizes solicitation generally and not just soliciting donations. That statute specifically is also unconstitutional because it's an unconstitutional prior restraint. And that argument actually, that's a winner. You know what I mean? Even if the state argued that under Austin, pedestrian solicitation statute should be subject to intermediate scrutiny, and And even if a court somehow found that it survived intermediate scrutiny, we would still win on the permitting argument. So, so as to Austin, briefly, we really emphasized the few lines in Austin where Sotomayor notes that the ordinance, it's an ordinance, right? Yeah, of course, it's location based. It's a location based regulation. And I mean, location based is definitely in there, right? Like to really, yeah, we want to view Austin, we want to cabin Austin, obviously. And so if you can cabin it to the world of location, right, on off premises, then you know you're doing the best you can, I think, to distinguish it from Mead. Also, we argued that the pedestrian solicitation statute, which let me just go back real quick, right, which lists out these categories or these kind of objects of solicitation, like what are you requesting? We analogized that formulation to the formulation in Read. In Read, you have the ordinance categorizing types of signs, directional, I don't know, like, so they're categories, I forget the exact categories, but based on those categories, or there were differing restrictions, different penalties, right? Like depending on the category. And so what we tried to say was, well, you've got categories here, right? Like this is not a general prohibition on all forms of solicitation because it's not prohibiting soliciting signatures. It's not prohibiting soliciting support for a candidate, right? And so it kind of plays on this idea of soliciting. What is soliciting, right? Is it only soliciting money? Right? So yeah, basically we wanted to kind of draw a almost like a larger denominator, if you can say that, right? Like if you broaden the scope of what you can solicit, then now you have a statute that is targeting, right, certain objects, right? In this case, employment business contribution. So like that was a strategy. But fast forward, the state like opted out in a way, right? Like the state's like, we don't want to argue with you on this because you win. Instead, we're going to say that soliciting donations for one's own use just isn't protected by the First Amendment. It never was protected by the First Amendment. The 11th Circuit might think that it's protected by the First Amendment, C. Smith, but they're wrong. So basically, you know, we're going to seek en banc, you know, we're going to appeal this and we're going to seek en banc review because obviously they'll lose before the panel under existing precedent. So yeah, here we have state of Alabama, you know, in some ways opting out because they would have had a decent case under Austin. You know, I think they were just too lazy. And then in other ways, really like possibly taking us to bat and everyone who works in this space to bat. And so I'm almost done talking, but I do want to, you know, what are they saying? They're saying that historically, as we know from like every single panel yesterday, right? Historically, begging, you know, was criminalized, right? Like see the statute of labor, see the poor laws, see vagrancy laws, and their kind of later incarnation post Reconstruction. And so, yes, you are right, state, but also that can't determine, you know, what's subject to First Amendment protections today. And so I do, you know, maybe during questions, like we can talk about that a little more, but I mean, I think if you are challenging this, I think you'd want to look at the cases. Also, we talked about yesterday, Papa Christos v. City of Jacksonville, Colander v. Lawson, Edwards v. California, each of which invalidated, not on First Amendment grounds, but on other constitutional principles, invalidated kind of neighboring elements of vagrancy law, right? Like so like what Colander was the you need to show identification, right? Edwards was you can't come in, and so the Okie laws, right? And then Papa Christo was the vagrancies, and so it's like there, you know, I think we just need to chip away at the legitimacy of, you know, statutes like this, right? Which is the statute that, if you'll see in the second bullet point, which is a statute that they cite. So you see where it says, let's see, sign an enactment that empowered the District of Columbia to criminalize begging by vagrants, idle, or disorderly persons. Now look at, you know, the full, a fuller section of that statute. You'll see in bold, that's the portion that the state quoted. I mean, I could highlight literally every line of this, but then what would be the point? Like it's, I mean, this is appalling. Yeah, it's gross. And so yeah. Oh, and then basically we decided not to reply to that response for a number of reasons, but one of which is that the state the state cited this law review article in the first bullet point, but that law review article doesn't cite anything basically for that sentence, right? So it's like, we're not going to make the state's arguments for it, right? If you want to appeal this, let's go. But until then, you know, have a good day. So that's it. Thank you.
Thank you. Okay, we are going to switch gears a little bit. Kirsten, if you would come back up here. Oh, yeah, my bad. We've got 5 minutes until the end. Well, I appreciate that. You know that I know that you and Ellen will be able to, you know, ask and answer questions later. And if during the transition, we're able to talk about it. Kirsten, I know that you are going to talk about Fort Lauderdale food not bombs versus Fort Lauderdale and food sharing as expressive conduct. That's the last, you know, portion of the First Amendment conversation we wanted to have. And sorry for the abbreviated time, but
I can do it quickly. Food not bombs, a lot of folks are familiar with them. They share food in public places to communicate the message that society should redirect its collective resources away from war and violence and towards meeting the needs of society. Fort Lauderdale food not bombs. The city of Fort Lauderdale had passed some regulations and started aggressively like arresting, shutting down demonstrations. There's a lot of political activism. I can't say enough about the organizing and the international news attention and all of that was going on against the backdrop of litigation. We sued under the First Amendment. We brought a straight expressive conduct on the basis of political communication. That's pretty rare. A lot of food sharing cases are about religious speech. Jennifer already talked about Clark and, you know, kind of what you have to show. Basically, you have to show an intent to convey a particularized message. Food not bombs clearly has that. And the second is whether or not a reasonable person will view their conduct as conveying some sort of message. That is a very factual, intensive inquiry. I cannot emphasize enough. We lost twice at the district court and we won twice at the 11th Circuit Court of Appeals. We pulled down unanimous decisions both times. The 2018 decision found that outdoor food sharing by our clients was expressive conduct under the First Amendment. And most significantly found that sharing food is inherently expressive conduct. They actually likened it to the flag. Those folks who know First Amendment jurisprudence know that the flag is kind of the height of symbolic expression. The quote from that opinion is like the flag, the significance of sharing food dates back millennia. And we had an expert witness in that case who was an anthropologist who traced the history of food sharing so it predates speech itself as a form of human communication. It's been documented in every clan, every tribe that communicates a message. And significantly, the refusal to share food always communicates aggression. And so what we were saying is by forcing them to not share food, they were forcing them to communicate a message, the opposite message of what they intended. We had so much factual evidence in that record. Happy to talk to anyone who wants to do something similar because it is quite like the opinion repeatedly says on this record it is accepted on this record. So that's really significant. And then they kicked us back down to the district court to see whether or not it was a reasonable time, place, and manner restriction, which is where kind of the folks in park lost. We went back up and won again in 2021, and they said that the park rule was unconstitutional, it applied to our clients. And then the case resolved for injunction damages and receipt. And that's the case I did also when I was at Southern Legal Counsel with wonderful First Amendment lawyers in the Costello and Chapman.
Excellent work. Well done. Thank you. Now, I apologize. The technical difficulties ate up a lot of time for questions, but we do have just a few minutes. So, Micah, do you want to ask your question?
I'm just gonna ask.
Gave you a snapshot. Like, but that was like, yeah. Okay. So Micah asked to ask you a little bit about ourselves. So we, thanks really to Tristia's guidance, in addition to settlement education for second, the city of Mead to establish a task force on homelessness that would center the leadership of people who are unhoused and unhoused. And in addition, the city agreed to donate $10,000 to an organization that would simply give the money out to people who need them to the store. And the city agreed to remove, essentially drop any pending charges under the two statutes. So essentially to do it. And over the past year or so, we've been working with the city to create this task force on homelessness. So well beyond just talking about social conditions alone, the city finally did it. Like, which was kind of incredible because it takes a lot of cities. Anyway, and finally, although I will say that we're with the cyclical nature of politics, we're seeing a backlash already, right? Like just the other week, we got a proposal from some of the police department to listen 6 other ways to but yeah, the community development department has a multi-year plan for how to increase access to housing. They're bringing unhoused people to the table. They're bringing stakeholders from real estate, from legal organizations, service providers to the table. And it's progress. So I will say the antipathy to people who say citizen donations is very strong. We have right? We have the community foundation in the area creating billboards that say "Give smart," right? Like, don't give to panhandlers, right? Give to our costs, and then we will distribute the money to service providers. So give smart, don't give stupid, right? Like, clearly that's the implication, which really does go to why this, soliciting donations is a trust activity that goes about part of this real divisive issue in our society. Giving smart, giving stupid, right? Like, it's evidence.
Thank you. And I think we have time for one last question.
Okay, so
the tensions here between people who are in the ecosystem.
probably going to be a factor in this process. And particularly if, you know, that if are someone find like how can they, if they don't want to spend their time have to do themselves out, and then they also don't want to having that do the not and you know, individual children, but also the other families that have to. I'm trying to all the long, honestly, but just like I'll give a short answer. So the family outside and I particularly controversial residential. And part of it is that a lot of folks in five signs use that money to purchase like hotel. They are not accepted. That there's some obviously some divisions that. And I was at this conference in South Carolina, so I got a background in Mead and also visible computing. And they looked into why that was, and they found out that it was not a meter shelter, it was going to be more inside. And that can be considered another background on camping actually together to the right. And I was going to shut it down before the house, but it was impacting that. So that was like not about all of this, and you know, it's really not essential, but system. And so I would like to do that more like doing people what the city is rather than yeah, I think ultimately I would be talking about we don't have better reason for a lot of those movements to be all of those stuff down and it's about like idle. It really is about so the guy, I think that is not not how we're going to.
Thank you all so much. All right, folks, people looking for CLE codes. The last CLE code is speech. Speech. This room is going to have the decriminalization session, and please stick around here. Otherwise, we've got a couple of other rooms with other sessions. Any questions about how to find your next session? All righty. Thank you very much. I'm going to step out. Alex, do you happen to know how I can get so I can't do screen share from my laptop. I've got a short little PowerPoint. Yes, I don't know what
Yeah. Yeah.
And also, yeah, I would say it's possible. Do you want to? Yeah. He was just I was just because he was just finding similar Anybody else sign the sheet? I don't want us set up.
You know, I think I'm gonna have to be sort of moving with the mic, so I think you can sit wherever.
Yeah.
Um,
There can be, yeah, there absolutely.